guys, it's Kathy. I hope you're doing well. This is better than the black screen, I think. No camera today. Hopefully my stuff comes in sooner than later. Hopefully. It'll only take me moments to fix it. Fix my computer once I get the parts. So, we'll be good to go. So we get to hear the end of this pro se now who's saying that he had ineffective counsel. And then we have a few fun clips that we'll end the stream with. Unless we pause a lot and talk. You got snow, Sandra. That's crazy. I wish we got snow. All right, let's get going.
That she testified to.
Right, but you would agree that she testified to that correct?
Objection.
No, I don't remember.
And
She doesn't remember Sylvia's testimony, so she said.
she doesn't recall what the specific message was that she sent out. I think it's what she testified to.
All right, give me a second.
I guess my question would be, so what? What's your point?
Your Honor, the evidence that the prosecutor had, Your Honor, this is around perjured testimony. The prosecutor should have known, Your Honor, that Sylvia wasn't testifying truthfully, Your Honor. The 911 tape the 911 recording that was disclosed to the defense by the prosecutor, Your Honor, established that the prosecutor knew or should have known that Sylvia's testimony was perjured. Sylvia is on the 911 tape. Her boyfriend is communicating multiple messages, Your Honor, that she is communicating with.
Okay,
so
what?
If Mrs.
We're not retrying the case.
Right, Your Honor, I'm trying to establish perjured testimony here, and that the prosecutor knew that the testimony was perjured. Your Honor, if the prosecutor was in possession of the 911 recording, the prosecutor should have known, Your Honor, that Sylvia's testimony was not truthful. Sylvia said,
so let's based on the evidence that you had in this case, Ms. Soto, was it your understanding that when the complaining witness testified at the trial, that she was presenting to you perjured testimony and you sat there and let it happen?
No, Judge, I do not.
Okay, Your Honor, based off the evidence that was included on the record of appeal, which included the give me a second here.
How you doing, Michael? Oh, okay.
Guys, I just popped a link in chat. It's for Team Skeptics video. Judge plays Uno reverse when sovereign citizen in court and puts him. I can't see the rest from this screen. But T thought that everybody would love that. Now I can't just steal something from Team Skeptic and play it here. But go and watch that then. You'll like it. You really will.
Your Honor, the evidence that was introduced into the evidence that Mr. Masters provided into evidence, the body cam footage, not Officer Sarge, but the body cam footage that was provided to Mr. Masters by the prosecutor includes the 911 recording, which would show that Sylvia had.
Right. So, sir, you're saying that she purposed. I read what you're saying, and your allegation is that the state knew she was lying and that they still solicited perjured testimony. And I asked, so we could kind of cut to the chase here, based on the evidence that she had at trial, was it her, was she eliciting testimony that she knew was perjured? And she said no. So unless you have any further evidence, I don't think you're going to have a Perry Mason moment here where, you know, suddenly says,
What is that?
she suddenly says, "Oh yeah, you caught me." You know,
I know I kind of.
Judge told him he's never going to have a Perry Mason moment. That's a horrible thing to say.
I kind of knew it was going to be a little hostile today, but was trying to figure out creative ways to elicit the testimony.
So she's already said she didn't have the. She did not knowingly elicit perjured testimony. So I don't know what else she could answer that question. How any other way she could answer that question.
Okay, Your Honor. I'll pass the witness.
You should convince.
You've done a lot of these kind of cases, correct?
Yes,
And you've seen video, body cam video, and then, let's say, talk to a victim afterwards.
correct.
Is it true there's times when the victim isn't, let's say, we're saying a lot of what happened because they're pretty traumatized?
Absolutely.
And so is it, I guess, a normal situation where the victim, as time progresses, gets a little bit more detailed in what happened?
Yes, that initial emotional reaction when you're in that fight or flight kind of state can affect your memory and how you communicate that memory, and then that memory solidifies as you have more time, more numbers of hours of sleep, and are able to be sort of in a physically and emotionally safe place where some of those details do come back. Yes. And we know that from experience in science.
Right, so just because someone isn't saying a lot of what happened in their initial interaction with police doesn't mean it didn't happen.
Correct.
And you were asked specifically about an unzipped pair of pants being indicative of trying to arouse on sexual urges. That's not the only thing or is indicative of that, correct?
Correct.
It could be just the act itself of whatever touching there might be. There doesn't need to be any unzipping of any pants.
Indeed. That's correct.
And so basically it's left up to the jury
Yes.
to make that decision.
So I don't know if you guys remember yesterday at the beginning of the hearing, the defendant, that guy, the per se guy, he wanted all of the records from the jail or the prison. I can't remember which one he was in. All of his records for this, that, and the other thing. And the guy said it would take him an hour to get it together. I think that's who we saw just come into the courtroom and hand a whole bunch of stuff to the bailiff. I'm not 1,000% sure, but I think. Now, I haven't watched past what we just saw, so I don't know what, except for the end. I saw the end. I don't know if he's going to get the warden on the stand or not, but that should be interesting if it does.
You did say that you remember some limitations on the phone, so whether or not there was a text of help or if there was an attempt to call police or any of those things, your memory is that the fact that she was driving for Uber may have limited the use of her phone.
Yes.
Okay. Now, you had a chance to look at the petitioner's petition for post-conviction relief, correct?
Yes, I did.
And I think there's one thing in there about a hoodie.
Yes.
And when you read that, did something click?
It did. As I think Mr. Masters mentioned that the victim's first language is not English. We had several conversations, she and I encouraged her that her English was good enough and she was confident enough to testify in English. She was easily understood. There were not any times where I felt like, that I needed to repeat what she said. She easily communicated her testimony in English. However, I do think that there are limitations given that English was her second language. So you might say that my hair is up, or you could be more specific and say that my hair is in a bun. Someone who has limited English might just say that my hair is up. Someone whose English is their first language might say that my hair is in a bun. Both are absolutely correct and are descriptive of how I'm wearing my hair today, but I think there might have been some limitations in how she described her clothing, for example. The difference between a hoodie and a shirt that
My hair is down.
is long sleeved might not come across accurately when English is not your first language.
And is it reason why the officers don't testify and what the victim tells them at the scene is because you're trying to avoid hearsay?
Yes, absolutely.
And if you try to put in evidence, body cam footage, like in this case, or police reports, is that something that you would get in without objection?
Unlikely, no. Or I should say, likely the defense is going to object. Yes.
So you don't even go.
I don't.
Nothing else, Judge.
Anything on that line of questioning? Lewis?
No.
Bren, that means your hair is down.
Luis?
Yes, Ron.
Thank
Thanks,
you.
Judge.
Thank you. Well, your next witness. I think that's the file from the jail. All of them. Can you call in next, sir? Do you want a few minutes to go through those records?
Yes, I do, Your Honor. How much time could I have?
How much time you need? 'Cause I'd like to get the testimony done today.
Your Honor, this is a pretty thick file here, Your Honor.
Well, why don't we do this then? Why don't we, why don't you call your witnesses, and then if we need to continue the hearing, although I prefer not to do that, but if we need time to go over that, those documents,
Your Honor,
I'll give you time to do so.
I would respectfully ask for a continuous, Your Honor, to go over this.
Well, like I just said, sir, I would give you time if you need time, but we've got some witnesses here now that don't relate to the jail records that why couldn't we call them?
We could call,
Mr. Kozalewski is here?
Yes, yes, Your Honor.
Yep.
And Judge, I think on a comment, I think the records are going to speak for themselves. So once gone through, I don't think we're going to need any other witnesses. It's just going to be a matter of what goes in and what doesn't.
Okay.
I mean, I don't think there's going to be a question of authenticity or record keeper. They're the records. I think we'd all agree with that. And it's always going to be whether or not they're relevant.
All right.
Your Honor,
I love it because I work at a place where they do a show. It's a dinner theater. So every shift I get to watch a show. I can't sit and watch the whole show. But, you know, while I'm filling the coffee, I can watch the show. While I'm emptying trash, I can watch the show. It's pretty cool.
I don't see, okay, go ahead.
You swear to tell the truth, the whole truth, nothing but the truth, so help you?
I do.
So have a seat.
How you doing, sir? Can you please state and spell your name for the record, please?
Christopher Kozalewski, CHRISTOPHER KOZELICHKI.
And I'm sorry, my pronunciation has been pronounced wrong for years now. I don't know. I have it saying Kolovitsky. What is that again?
That's correct. Kozalewski.
Okay. Where are you employed at, Mr. Kolovitsky?
I'm a deputy public defender with the St. Joseph County Public Defender Agency.
And how long have you been a public defender?
Ooh, I started with them part-time back in 2021 in October. And I've been full-time now with them, I believe, since July of maybe 24. It was in 24 or 25 that I went full-time with them.
Okay. Do you recall back in This will be March or April of 2022 when you represented the petitioner Omar Lewis on appeal?
I do.
Okay. Do you recall what arguments you raised in your brief?
Yes, the main thing that I raised in the brief was that the state had failed to present sufficient evidence to prove that there was a threat of force or actual force used to facilitate the battery there. I've been considering a couple different options. There was a mens rea issue with gratifying sexual desire, but some of the evidence in the transcript, as I read it, kind of ruled out that as a viable appellate issue. So I wanted to stick with what I thought was the stronger issue, which was the kind of the force or threat of force angle there, because I think of the things that the state got out of the witness, I think that was the victim. That was the weakest set of facts.
Okay. Let me back up for a second here.
Sure.
You had a chance to review the petitioner's trial record, is that correct?
That's correct, yes.
And you reviewed the trial record in its entirety, is that correct?
Absolutely.
Okay. And were you aware that there became a point in time where the petitioner represented himself?
I am very aware of that. So yeah, and that's kind of what I meant with in the latter half of the transcript. It looked like Mr. Masters that initially he was attacking some things that I thought might be able to bear fruit on appeal. But then when we got to the pro se segment of the trial, some of those things ended up getting kind of cut out from under them.
Okay. But you are aware the petitioner represented himself?
Yeah, in the second half of the trial, yes.
Okay. Now, you say that you reviewed the trial record in that matter. Were you aware that the petitioner in that matter had filed a motion to correct error?
Oh, on the verdict? I remember having to talk with the court about some issue with it. I think part of it was, I can't remember exactly what it was, but there was an issue with getting the notice of appeal onto the CCS, I think. And around that time, I think it was because I can't remember exactly why that ended up being the case, but I think there was a motion to correct error that was filed before I was appointed on it, if I remember right. And so I filed the notice of appeal well within the timeline because it was extended based on that motion to correct. If I remember correctly, it's been several years since I did this.
So you are aware of a motion to correct error that was filed in that case then?
Again, I have a vague recollection of that happening, and that's why I believe I had an extended period of time on the notice of appeal, because that's what my memory is. But I'd have to see the CCS to recall that fully.
You said you would have to see the CCS.
Yeah, chronological summary. If I saw that, yeah, it'd be clear. But as I said, I have a vague recollection that was the case. But that was not something I filed. I don't believe that was something the PD agency filed. That was something that was kind of irrelevant to my needs as an appellate attorney, aside from the filing deadline that I mentioned.
Now, did you review that motion to correct error?
Yeah, I would have. So when I get an appeal, the first thing
So this guy on the stand right now is, okay, he lost his case. Big time. So then he took it to an appeal. He did take it for appeals. The guy on the stand right now is his lawyer for when he in his appeal case, which he lost, by the way. Monica, thank you so much for the cheers.
I do is I go through the CCS as I mentioned, and I look for any kind of what I would call substantive motions, things that the court would have ruled upon that might be an avenue of appeal, motion to suppress, if there is any delay issues, things like that. They don't come up that often in terms of delay issues and things like that, but I still look at that. If I see a pro se motion to correct error, yeah, I will review it, but usually I don't take my cues on legal issues necessarily from a pro se litigant. It might be helpful, but I reviewed it as part of my regular review.
Now, the petitioner raised some issues in the motion to correct error that the petitioner believed were that maybe could have been some good grounds for appeal. You don't recall, just off the top of your head, do you recall what the contents of
I believe there was talk of ineffective assistance to counsel, but again, just to, I guess, if I'm understanding your question correctly, sure, there could be something that a pro se litigant believes is an issue on appeal, but I trust my judgment on the law, which is what my job is as an appellate attorney, to review the record as it exists and try to figure out what issues best merit taking up to the.
What are you talking about? The prosecutor and me are assuming the exact same position right now, and I'm very interested.
Court of Appeals. It's a little bit different than in a trial setting. In a trial setting, when you're trying to develop a record, having a long conversation with a client about, what their view of something that happened was, can be really illuminating, for instance, with a body cam footage, there may be a body cam that's showing a what looks to be a fight, but when you talk to the defendant, you get some additional evidence. It may turn out that this is some type of subterfuge by the officer, kind of lunging in and out. There's been resist cases where I've seen that happen. But in an appeal case, it's a bit different because what I have to work with there is just the record. And that's the only thing that I can really bring out there. There's not an opportunity to further develop evidence and whatnot. So what is most substantive to me and what is the most useful as an attorney is what is in the record. So that's where I spend most of my time when I was doing appellate cases.
Okay. Mr. Koliski, when you take an appellate case, do you usually communicate with the trial counsel prior? That was. Oh,
yes. Yeah, and I try to, and a lot of times it's something informal. We see each other in court quite often, and I'm in any number of courts on any given day. So at minimum, I'll usually pass along, hey, I picked up this case. Is there anything I should know? In this case, I believe, if anything, I would have talked to Mr. Masters in court. I didn't send any emails or anything on this one, I don't believe. So, yeah, it can be helpful to from them to get their take on it. And my recollection in this case is that, I found out about the termination of counsel before I actually got the transcript, because I actually don't get the transcript for some time after I file that notice of appeal. So I believe I was clued in that it was a pro se in the second half of the case.
Okay. Do you recall talking to the petitioner in this case about his pro se representation in this case?
I sent a couple different letters to the DOC, and those were returned to me in the mail.
Okay, so they did not get to him.
That's correct. And I believe at the same time, the court had also had several of its orders returned. that had been sent out to the DOC. So I don't know what was going on at that time, but there was some sort of problem where I was getting returned, and so was the court.
Okay.
We've sat here and we've watched this chair be crooked for the last 2 hours and 16 minutes of this video. So I'm moving it so I can't see that crooked chair anymore. Yep, we can still see the carpet though. Don't worry. Brad, don't worry.
You would have to have a copy of those, would you?
Not on me. Brought me here today from my office.
Yeah. Okay.
No. No, Brad. If it involves a snake, I'm deleting it. I'm deleting your message. If it involves a snake, I'm deleting your message twice. Okay. It doesn't involve a snake because not very many of us eat snakes. We're good. Continue with your food talk, please.
So you never spoke to the petitioner about trial?
No, and
Trial.
that's not terribly uncommon, especially for DOC clients, sending the letter down and trying to initiate contact and letting them know what's going on, is one of the main things that I do and try to update them, and again, with this one being returned, by that point, there are deadlines that have to be met. And again, for me, at least, communication at the appellate level is more about updating on what's going on, because from my view, in my view as an attorney, those strategy decisions are entirely appellate counsel's. Except obviously with dismissing an appeal that had happened before, where someone has just said, "I want to continue on with the appeal." But in this case, I didn't have anything like that, so I just proceeded as I normally would.
Mr. Kozlowski, the petitioner hired you as private counsel, correct?
Incorrect.
Okay, you were appointed by the state?
I was an appointed public defender on this one.
Okay, Mr. Kozlowski.
He doesn't know that he didn't hire him? Don't lawyers cost thousands and thousands and thousands of dollars? Don't you think you would know if you actually hired him?
When you're appointed by the state, okay?
I'm appointed by the public defender agency.
Okay, when you're appointed to represent a petitioner or someone in appeal, and you're appointed by the state, it's not necessary to meet or discuss the case with that defendant or petitioner once you enter in your your appearance. Is that correct?
Again, it depends on the type of the case. In trial court, obviously, there would have to be an in-person meeting. There would have to be at least some discussion on this. Appellate is different in that, again, what we're talking about is exclusively the record at trial, and that's not something that can be added to or modified.
Okay.
So in those cases, no, I do not have to.
So it's not necessary at all. Okay, on appeal, you've asked that question. Okay. Mr. Kozlowski, so you just testified to it's not necessary once you enter appearance in that case. Now, you didn't speak to the petitioner about this. It's not necessary. This was an appeal. Would you would have known that the petitioner? Let me back up for a second. Did the petitioner directly speak to you about filing an appeal on his behalf?
No, but you did send a couple different letters that I did receive that indicated kind of your thoughts and feelings on things. And in the second letter I sent you, I tried to address those concerns. But again, that letter was not received.
Your Honor, at this time, I'd like to enter into evidence, Mr. Kozlowski's brief, appellate brief, Your Honor.
Judge, the whole record's there already. The appellate record.
Your Honor, I'm trying to enter in a physical copy because this case is pending in federal court also, Your Honor. So I would like to enter in a physical copy.
Is it stapled together or is it loose? Here, give it to me.
I'm trying to get as much evidence over to the physical over here as possible.
Oh, he's still incarcerated. He's still incarcerated, guys. Is it stapled together, the judge said. The inmates aren't allowed to have stapled anything. Because he's wearing street clothes, but I didn't see, like, them bring him in handcuffs. I don't know.
No, what is this? Is it E?
I think we did
Did we do E already?
Yeah, we have. This is F. I'm sorry. Let's go this brief here.
I'm gonna let it in.
Well, it's already in, right? I mean,
Right.
we already said the appellate record was in.
Right.
I didn't recall, but
Maybe. Which in?
okay.
I'm sorry, that's petitioner's. What's E?
Mr. Kozlowski.
Hang on a second, what's he?
I think it's
The transcript of the.
Oh, yes. Go ahead, I'm sorry, go ahead.
Mr. Kozlowski,
I prefer when my cookies are a little more well done, crispier than chewy.
the notice of appeal here, you filed plenty of appeals before,
Right.
is that correct?
He didn't get permission to approach the witness. That's why the bailiff jumped up. Now I don't know where the bailiff went now.
On a notice of appeal, does the notice of appeal give the petitioner option of automatically appealing the denial of a motion to correct error?
I don't understand the question. Can you repeat it?
Okay, when you file a notice of appeal, the notice of appeal give the petitioner the option of appealing his motion to correct errors.
If I'm understanding your meaning, there are several different codes that you appeal from. So there's the idea of an interlocutory appeal, there's an appeal of a final judgment, there's an appeal on a motion to correct error. That is simply a notice to the Court of Appeals on kind of where you're appealing from. That can be done for timing reasons or whatever, but yes, that is one of the things that you note on the appeals, what type of appeal it is. Again, if I'm understanding what your question is, and I'm still not entirely sure I do.
Okay, maybe I could rephrase it in a second. Give me a second. I'm looking for some. Maybe a second here, Your Honor.
Judge Crawford right now
Do you want to ask him why he didn't
would
appeal your
not be
denial of
Yeah, I want. Excuse me. I want to. I have some documents that I want. I'm sorry. All right, give me a second here.
I have not seen Judge Crawford stream in quite a bit. That's why we haven't watched any. None of those chairs in that whole place look very comfortable except for maybe the one the prosecutor and him are sitting in. I would stay there if I was going to take a nap.
this time,
I think the prosecutor just doesn't want to look or talk to him. He doesn't want to look at him. He doesn't want to have to lower himself to argue against a pro se. It's not right.
Your Honor, at this time, the petitioner respectfully requests that the court take judicial notice, Your Honor, of the Indiana Rules of Professional Conduct 2023 edition, which states that it deals directly with an attorney-client relationship. Your Honor, Rule 1.4 communication states that a lawyer shall reasonably consult with the client about means to which the client objectives are to be accomplished. Keep the client reasonably informed of the status of the matter for properly comply with reasonable requests from the client. Reasonable communication between the lawyer and the client is necessary for the client to effectively participate in a representation. Paragraphs 3A2 require the lawyer to reasonably consult with the client about means used to accomplish the client's objectives in some situations, depending on the importance of the action, of the consideration and feasibility of consulting with the client. This duty will require consultation prior to taking action. Your Honor, the petition respectfully requests that the court take judicial notice of the Indiana Rules of Professional Conduct 2023. Your Honor.
What was that rule again, sir? What did you say, 1.4?
The rule, yes, the rule is 1.4.
Okay.
Client relationship.
All right. Take
And then
judicial notice of the
I'd like you to take judicial notice of the Constitution as well.
rule.
I wouldn't think you do that, they exist.
Excuse me?
That rule exists, yeah.
Yeah, they exist. Here's your rule. You can
Yes.
cite to it anytime you want.
All right, so I'll ask the court to take judicial notice of it this time, Your Honor.
I just did.
Okay. This actually was filed in a motion, Your Honor, back in March of 2025. So, okay. Now, Mr. Kozlowski, the petitioner raised an argument about being erroneously appointed counsel in its motion to correct error. Did you happen to see that?
I did.
Okay. You didn't think that had any merit to it at all, did you, Mr.
Zero.
Kozlowski? Excuse me?
Zero merit.
Okay. So why would you say it didn't have any merit, Mr.
Well,
Kozlowski?
a couple of reasons. Raising ineffective assistance to counsel and issues like that.
No, it wasn't an ineffective assistance counsel.
Let him answer the question.
Raising issues with regard to counsel at the appellate level leaves you with the record that is extant at the time, at the end of trial. And most of the time, that is an absolute bar then to raising that issue in further PCR proceedings, which would prevent you from doing the hearing that you're doing right now. So as a matter of practice, generally speaking, unless something was very obvious or there was a reason to do it that would not preclude the client from being able to raise that issue on PCR, I do not raise issues of counsel, generally speaking. And that is pretty common practice across the defense bar.
I shouldn't say what I'm eating right now because it'll spiral into a whole thing. I'll say I'm eating graham crackers. And then the people who are not from the United States will say, oh, how many grams? And then all the people from the United States will think, oh my gosh, Kathy's selling drugs.
Okay, The petitioner also raised a Brady violation issue, vaguely in his, motion to correct error. Actually, it wasn't a Brady violation, it was a failure to collect and preserve material exculpatory evidence. And you didn't think that had any merit to it either, did you?
No, because again, you're stuck with the record that you have at trial.
Okay.
When you're dealing with an appeal. And an issue like that is best served in in a venue where a proper factual record can be developed outside of the trial record.
Okay.
And
So, go ahead. No, go ahead. Sorry. Go ahead.
And again, by raising that issue on appeal,
Hi, Bobby.
the client then is potentially putting themselves in a much worse position when trying to raise a PCR issue, again, as you are doing right now.
Okay. Now, in your appellate brief, you raised the issue of you raised the issue of the sufficiency of the evidence, is that correct?
That's correct.
Okay. Now, the petitioner in this matter had 2 crimes he was charged with. Are you aware of the crimes he was charged with?
It was a sexual battery was primary on this one, and I don't remember what the lesser was on this.
Okay.
But the sex bat was the most.
Do we recall that he may have been interference with the recording of the call?
Oh yeah, that's correct. Yes.
Okay. So you chose not to appeal the petitioner's conviction for interference with recording of a crime. Is that correct?
Yes, that's correct. So in this particular case, I felt that in my strategy on appeals, as well as my strategy at trial, I don't like the spaghetti on the wall approach. Throwing every potential issue on the wall and hoping to see what sticks, I have found to be ineffective. And when I saw that when I was a prosecutor, I saw defense attorneys throwing lots of things at the wall. Oftentimes it didn't work. So then when I came to the defense bar, I took that lesson forward. And I found that I have gotten better results by drawing the court's attention to the strongest issue, focusing on that first and foremost, rather than looking like I'm grab bagging on things. I think it helps establish credibility when you're making an argument, especially when you're talking about sufficiency of evidence. It's already a tough road to hoe, and it's a tough standard to overcome. And going in and throwing everything at the wall, I think, in my experience, appeals courts will tend to kind of, I think that they might view those other arguments as less than credible. And in this particular case, I think there was a very credible issue to raise, as I said, with regard to the force or threat of force element. The interfering with the reporting of crime, there was simply not that level of ability to dispute that, to my view.
Mr. Kolovitsky, the petitioner had a constitutional right to appeal that conviction. Is that correct? His conviction for interfering with the reporting of crime, he had a constitutional right to appeal that conviction. Is that correct?
You have the right to appeal every case, yes.
Okay.
Every case.
So you didn't speak to the petitioner about that issue. I mean, you didn't speak to the petitioner at all. Is that correct? Doing your representation?
Oh, that's correct. Yes. As I said, I sent a couple letters. Those were returned back to me, and then I received letters from you as well. And as I said, I tried to respond to that, and that's what that second letter was, laying out these things. And I knew full well what you wanted. But again, in terms of strategy, which is the appellate attorney's role,
Exactly.
strategically, I think it made more sense to fight it the way I did.
Okay. So you didn't know if, in fact, the petitioner wanted to appeal that conviction or not, is that correct?
Objection, that's an answer. Just explain the whole thing.
I'll let him answer that question.
No, it was clear from your letters that you wanted me to raise other issues that I was not raising and was not going to raise. Again, I understood those, but again, looking for the best possible result in the case, I made a strategic decision to focus on what I thought was the strongest, and again, focus on the charge that hopefully could be overturned that would have the greatest amount of impact on petitioner's life. That's where I'm coming at this from. Strategically, if I got one bullet, I'm going to use it on the best charge there. And that's how I felt about this. And that, again, trying to argue the other charge I didn't think would be as effective. And I think it might actually diminish the arguments in the first.
Mr. Kovaleski, do you believe that your lack of communication with the petitioner may have harmed his representation in this case?
No, not at all. And, you know, in this particular case, if what you're saying is because I didn't listen to you and I didn't do what you told me to do, did I put you in a worse position? No. As I have said before, this hearing is happening because I made the decisions that I made. You would have waived many of these rights that you are now trying to advocate on. So sometimes an attorney's job is to help a client from themselves.
Mr. Kovaleski, according to the rules of professional procedure, would you say that you...
Ben, I'm sitting here swearing because I forgot. Now, I don't work today, so it'd be useless to do it today because it's just my cats, and they don't give a crap what I call them as long as I feed them. So, tomorrow. I work tomorrow. Tomorrow, everybody's mate.
Reasonably consulted with the petitioner in this matter?
Objection, Judge. Well, already.
I can actually...
Hang on.
He wants to answer this one?
I can answer that. Yes, I do believe I was in compliance with that. And I think the disciplinary commission, as you filed a complaint against me and they ruled it did not have merit.
So, Mr. Kovaleski, if the petitioner in this matter would have changed his mind about filing an appeal in this matter, you wouldn't have known because you didn't communicate with him, correct?
Again, I received your letter. I tried to respond to that letter. It was returned to me. If you would have sent me a letter to dismiss the appeal, I would have.
Sir, don't argue with him. You ask him a question. Wait a minute. I will tell him what to do.
No, wait.
You're asking the questions. You need to let him answer the question.
Okay.
Go ahead, Mr. Kozlowski.
If I would have received a letter requesting a dismissal of the appeal, I would have dismissed it. I have dismissed other appeals before. I have instructed the court that someone wishes to file a notice of appeal. I've been appointed on it, and the client eventually said, no, I don't want to appeal it. That has happened. And that is the thing that absolutely, that is your right to make that particular decision. Whether or not to dismiss it or continue on is your decision. The other ones are strategic decisions, as I've indicated.
Mr. Kovaleski, the petitioner here is alleging in the petition that you, excuse me, back up for a second here. Now, the petitioner here in his motion to correct error raised a fair opportunity to retain counsel of choice issue in his motion to correct error. You don't believe that that issue was stronger than the sufficiency of the evidence, right? Do you?
Certainly not.
Till you won't drink Jägermeister? Jäger.
No, in this particular case, You fired counsel in the middle of trial. You wanted an opportunity to hire counsel during the middle of trial, and the court told you no. And they gave you ample opportunity to either keep your counsel or go pro se, but you were going to continue on that day. And I felt like the record was very clear that you were given the option to do that. And the court's reasoning, that I found no problems with it, that they did not grant you that continuance. I don't believe that's a failure to provide you with opportunity to get counsel.
Okay.
There was a cat on it. I'm not losing my cat.
Give me a second there. I'm sorry to thought this for a second. I'll get up, try to cross all my T's, dot my I's. But, if we're gonna go back here for a second, I have just one more question here about the notice of appeal. Mr. Kozalewski, are you aware that the Indiana rules of appellate procedure rule?
I hope you're all happy. I moved my cat off of my mic, and now she's unhappy, but she's still purring. A little bit.
9 initial appeal states that the following shall be attached to this notice of appeal if applicable. If applicable. That is a motion to correct error. Okay. Mr. Kozalewski, what does shall mean to you in a legal sense when you see it on a document?
That you need to do something.
Okay. But it's not mandatory. That you need to, but it's not mandatory.
No, shall means that you need to. Is there a follow-up question to this?
You didn't attach the notice of appeal. You didn't attach the motion to correct error to the notice of appeal, did you?
No, because that rule is about appealing attaching which judgment order that you're appealing. In this particular case, my appeal was on
Bobby, that's savage.
the sentencing order in this case. The motion to correct order was not necessary. If you notice that the last part of that says if applicable. In this particular case,
Okay.
It was not applicable.
Okay. Mr. Kozalewski, what harm would have came by you attaching that notice of appeal?
Sir, excuse me, in regard to your PCR, the question is how the fact that, hey, what harm would it have been to attach my motion to correct error to the notice of appeal? How does that change the outcome of the appeal? How does that affect the outcome of the appeal?
Your Honor, he did not.
When he's already testified that he's not required because he's not appealing to the denial of the motion to correct error. So he doesn't need to attach it pursuant to the rules. So how does that change the outcome of the appeal? Which is really what you need to get to.
Your Honor,
not what, hey,
if
it wouldn't have been harmful. Let me finish, sir.
Thank you,
It
Bobby.
wouldn't have been harmful for you to just attach it. So what? So what that he didn't do that? The rule says he's not required to. So how does that change the outcome of your appeal?
Your Honor, there is a possibility that I myself wouldn't be sitting here trying to litigate this case right now if Mr. Kozalewski had attached that motion to correct error.
How so?
The appellate court would have had a chance to review the issues that was raised on the motion to correct error, Your Honor.
And he already talked about, he did that, his strategy was to go with the strongest issue. And he thought the strongest issue was the conviction for the sexual battery. He's already testified to that.
Your Honor, a motion to correct error is automatically appealable, I do believe, Your Honor. Just attaches to once you attach it to the notice of appeal, Your Honor, it's automatically appealable for review.
I actually do, the court did review the motion to correct error as it was included in my appendix. With any appendix, I put every motion that was filed in the case and the court reviews those appendices. So every motion is attached to it. So just because I did not attach it to the notice of appeal does not mean it was not transmitted to the Court of Appeals. I transmitted everything, even the pro se filings to the court, even the return mail slips in my appendix. And you should have that in your record.
Pass the witness, Your Honor.
You convinced me.
No questions, Judge.
The release from the subpoena.
Yeah.
Mr. Lewis?
Give me a second, please. All right,
I'm sorry.
so that's the release from subpoena. Okay.
And Mr. Kapinski? Thank you.
Yes, Your Honor.
Lucky
Thank
I
you,
could say your
Donald.
name wrong for
Thank you
years.
very much.
Everybody does, Your Honor.
I pulled the list sheet.
All right, so we have one witness left to go, right? Is that the warden?
Yes.
So, here's what we're gonna do. Mr. Kapinski, going back to Indianapolis today?
I might just stick around. I mean, it's.
So that's what we're gonna do. I'm gonna give you an hour to go through those records, and then we're gonna reconvene here at 2:00.
Okay.
And my other question, Judge, is if petitioner is
Thank you,
going to
Kelly. Thank
testify.
you.
Are you testifying, sir?
Yeah, I do not know right now.
Okay. All right. Okay.
All right.
All right, see you at 2:00.
2:00? Okay.
Okay. Ready? Ready, Mr. Lewis?
Yes.
We're gonna call the warden then?
Yes.
Okay, let's go out and get him out there.
Okay, we got the warden. This should get good now. I don't know, but this should get good.
Ready.
Come on up here, warden, I'll swear you in. Raise your right hand for me. Please, you swear to tell the truth, the whole truth, nothing but the truth, so help you.
I do.
Have a seat right over there, sir.
Where's Liz at?
Pardon?
So where's Liz?
We're recording. She had another deposition she needed to take. So we're recording. When she's done, she'll come back down. But everything's done being recorded.
Okay. Sir, can you please state your name for the record,
Lee,
please?
thank you so much. Thank
Can you
you.
please spell that for the record?
Oh, no.
F-I-N-N,
That
Mr.
stinks.
Fan, where do you employ that?
San Jose County Jail,
How long have you employed there, Mr. Fan?
17 years,
Okay, so you would have been employed there in September 2022, is that correct?
correct.
Okay, do you recall the incident that where the petitioner, Omar Lewis, was incarcerated in a jail, back in September 2022?
No,
Okay, okay, the petitioner in this case, while he was incarcerated, in the St. Joseph County
Objection,
Jail.
Judge, he's going to testify and leading, I'm sure he says.
Your Honor, this was a
He
question.
doesn't know about it. So
Okay.
if the form of the question is testifying,
Excuse me.
I'm objecting to.
All right.
Okay.
So change this to.
No, I get it. I get it.
Okay.
Mr. Finn, do you recall, a grievance in which the petitioner, Omar Lewis submitted, about being on suicide watch?
No, not until earlier when you showed it to me.
Okay. All right. Would you be able to identify your number and name on these grievances that the petitioner, submitted to the county jail?
Yes.
All right. I'd like to.
You need to grab. You need to fill in for Liz and Mark.
Yeah, I like this. Off of that exhibit.
The G,
I think we have G now.
the H.
Please give him some pizza. Please, please, please give him a little bit of pizza. All of it. You get a little bit and give him the rest.
That's up to you, man.
And FG, right? This is exhibit G, I believe.
Okay.
And exhibit G's 2 grievances?
Yes.
Okay. And, why don't you show those to Mark real quickly and he can find it.
What changes are they? Pages at the bottom.
Yeah, 14 and a half. Yeah, I'm gonna have one.
Okay. Yep.
It doesn't matter if he eats it or not. I'm going to put a pizza in the oven, guys. I'll be right back.
Your Honor, man.
Yeah.
It'd be a minute, Mr. Finn, to read the. I said give you a minute to read the documents. Okay, Mr. Finn, would you say that that is your signature and, badge number, and that is a fair representation of the copy of the grievance that you, replied to?
Yes.
Your Honor, I'd like to enter in, petitioner exhibit A evidence, excuse me,
That's G.
it's G.
Mr. Kapinski.
Judge, if the objection to the LC with the relevancy is
Can I see?
that it's a grievance, and we did talk about initial hearing at some point, but
Let me just look at this.
Your Honor, the documents.
Can I just read this a second? Just give me a sec. Okay,
Excuse me.
over the state's objection, I'll allow petitioner exhibit G. It's in.
Okay, thank you, Your Honor.
Yeah.
Also too, your Honor, all, this right now is with respect to petitioners, ground B, fair opportunity to retain counsel choice. Petitioner trying to establish that he was on, suicide watch at the time of the initial hearings. Warden, and, do those grievances represent that the petitioner was on suicide watch on the dates that the petitioner alleged in the grievance?
Yes,
Okay, so you would agree that the petitioner was on suicide watch from September the 3rd to September the 8th?
yes,
Okay, and you brought some records to court today, is that right?
correct.
Okay, and those records are records that reflect that the petitioner was on suicide watch while in Central County Jail, is that correct?
Correct.
Your Honor, at this time, I'd like to enter into evidence the complete file that the warden brought with me, Your Honor. The file establishes that the petitioner was in fact on suicide watch, Your Honor, from September the 3rd to September the 9th. It's the complete inmate log and this documentation that the petitioner was on suicide watch. Your Honor, I can turn to evidence.
Mr. Kapinski.
Well, Judge, I think we've already established this grievance time period. However, maybe to make things easier, if the court would want to review the documents and determine whether or not there's any relevancy for them. We don't even know if they're the complete records. We don't, we're just being handed a folder.
You want to ask him, you want to voir dire the witness?
Excuse me?
I'm asking Mr. Kapinski if he wants to ask me, because I'm assuming you moved to admit petitioner's age. Did you want to voir dire? Warden?
Or in the documents that you provided, that's specifically what was requested, correct?
Correct.
So if there's other records out there, we don't know.
Correct.
Oh, and you yourself, are you no other than this grievance of anything that's contained in those documents?
What?
Yeah, the ones you brought.
No, I didn't read them.
Okay. That's it, Judge.
Excuse me.
Hey, hang on. So do you have an objection?
I guess my request is if, instead of going through each document, it would take forever. I think my objection is there's no relevancy to
Okay.
where we're at, and if not, they're cumulative. So,
All right.
but you want to review them?
Yeah, so all right, your objection, I'm going to allow the admission petitioner's age.
This is the complete file from.
Well, so let's mark it. And you want to ask some questions about it, other than about the suicide watch?
I mean, I don't believe he would have any, I would have to be talking to a doctor about anything else there, but he just,
All right, so you don't have anything you want to ask him other than anything
no,
else?
he identified the suicide watch. I mean, like you said, it'll speak for itself.
Okay. I think Mr. Kapinski said,
Is that what?
all right, so no more questions for the warden?
I don't have these.
Mr. Kapinski?
No, Judge.
All right. Is he free to go now?
Yes.
Okay, thank you.
Thank you, Judge.
Sorry it took so long.
I apologize, only 2 and 2 today. I apologize to him too.
All right, so, Mr. Lewis, any other evidence that you want to put on?
At this time, I do not believe, Your Honor, I have any other, I would like the courts to take judicial notice, Your Honor, with respect to ground B. So Indiana Code 35-3375, which,
Wait a minute, 35 what?
35-33-57, which, is informing of the accused, which states in whole and part, at the initial hearing of the person, the judicial officer shall inform the person orally in writing that 1, the person has the right to retain counsel and the person
I
intends
can
to.
read the statute, sir.
Okay.
Okay.
All right, Christy, I just typed your name in correctly twice. I used a K both times. And it is popping up with a C. Oh, it's popping up with a C? Nope, look, Monica's was K. Look, all right, I'll use the bubble. I'll use the bubble this time. All right, I see your name. It starts with a K. Oh my gosh, I don't understand. I just did it twice with a K, and it came in with a C.
Objection to that, do you, Mr.
Excuse
Kibitsky?
me, sir.
Mr. Statute?
Excuse me, Your Honor. There was judicial notice of Indiana Code 35-33-75. There is a request for judicial notice for Indiana Code 35-33-7-6, which is indigent defendant assignment of counsel. And then there is.
Thank you, my voice. Thank you so much. I appreciate that. I'm glad that you chimed in.
Indiana Code 35-33-7-6.5 is the procedure to determine indigency. I'll let the court to take judicial notice of that.
Judge, I assume we're gonna have findings of fact conclusions
Right.
presented to the court.
Yep.
And if you cite any statute in there, you don't need judicial notice because it's a statute. So if you want a judicial notice, or the fact that do we need to note the rest of the statutes that we have? We don't think so.
I think if sir, the statutes themselves speak for themselves. And so if you're going to cite to them in support of your argument, then I'm going to take it. Those are actual statutes, and I'll look at them. And if they aren't what you say they are, then I won't take judicial notice of them. If they are, then I'm just going to accept them as they're written.
Okay.
Okay?
Yes, yeah.
And I don't have any reason to doubt what you're telling me isn't inaccurate. But
So you will take judicial notice, you said?
if they're accurate, if what you're telling me is accurate.
Okay.
Okay? So you're going to cite, I'm assuming when you do your conclusions of
fact.
your findings of fact and conclusions of law, that you're going to cite those statutes and
I'm
not look them up.
I'm almost finished with that already. I need a weekend to do it.
Okay, well, I'll give you more time to do it.
Okay.
Okay? Anything else, sir?
Your Honor, with respect to the petitioner's ground D newly discovered evidence, Your Honor, I'd like to make argument, Your Honor, on that basically the newly discovered evidence, Your Honor,
Isn't that what our findings of fact conclusion?
Yeah, that's what you do with your.
T. I know what you could do with that kitten bottle. Do you remember that case I put on? Like a week or two ago? About the boyfriend's bottle that was contaminated by by the person who lived in their house?
Findings of fact and conclusion of law, which is required under the rules, sir.
okay. I wish you would call me, help me out a long time ago, Mr. Benson.
I'm helping you out, sir. We're just trying to.
All right, so what else you got, sir?
Okay, let me finish it up here. The last one, Your Honor, was round F, Your Honor.
There is zero chance I'm going to use a breastfeeding device for a goat. I mean, there's a lot of things I will do for $5. That is just not going to be one of them. I just feel that I would be hurt in that situation.
Your Honor, this was all on the record with respect to round F. The petitioner attempted to have Officer Boyd call for a witness. Officer Boyd was subpoenaed by the court. At the time, the court stated that he's not able to testify. The petitioner is arguing that the court.
It's a findings of fact and conclusions of law where you can make that argument. Make it right.
Okay.
Okay.
Sure.
Every one of these.
I just want to put on. I just want to put on the record that I'm actually speaking on it or making an argument of trying to make an argument of it.
You're going to make an argument when you file your conclusions of law or conclusions of fact.
And not only is it Easter, Pennsylvania happens to be ranked number 2 and the enthusiasm for Easter candy. Michigan beat us. But there's going to be lots of candy happening this weekend.
Conclusion of law.
You know, finding of fact and conclusions of law. Better wrote that. But no, you can make all the argument you want, and that's why we do it. So it's all in writing. So if things don't go your way, you have a record of it, and the state, if things don't go the state's way, they want to feel it, they have a record.
Okay.
Okay?
Well, Your Honor, I'm done.
Include that. Mr. Kubinski?
Well, just want to make sure one thing, something was filed, some kind of statement. And that's not evidence in this at all. It's filed.
Talking about affidavits?
Yeah, I know yesterday, some kind of,
These?
no, some kind of statement by petitioner, I believe. In order, I just want to make it clear that he's not getting an opportunity to say anything about his case unless he wants to testify. There is no other filings that's all of a sudden going to appear in this as part of the record.
Not as of today.
And that, but he also, in his findings that law, does not get to testify. He gets to go with what's in his court record, which I'm wondering, are we going to need a transcript for down the road?
Well, I was thinking of that when Mr. Lewis was talking. Mr. Lewis, would you like a transcript of this hearing?
Yes, I will, Your
It
Honor.
might be a benefit because I think you may be a little premature in drafting your findings of fact and conclusions of law, because I think it would benefit you with the state to have a transcript of this hearing. So
Okay.
you would have everything, and then you can cite to the record, page 50 or whatever.
Okay.
When you're, so, now, if you want to, these sworn affidavits you filed today, I think this is what you're talking about. This is the only thing I have, unless there's something that hasn't showed up for me.
Oh, that might be it. That's,
Is that what you're talking about?
yeah, which would object in any way for this to be before the court. If he wants to testify, I mean, this is his opportunity.
Your Honor,
Do you want to say?
Your Honor, sworn affidavits are the same as testimony, Your Honor. I don't understand what the problem would be with me submitting those affidavits.
If we're doing it on submission of affidavits, yes. But we're not. We're having an evidentiary hearing, so you're more than welcome to testify, sir, if you'd like.
Sure, I'll testify, Your Honor.
So you want to raise your, we were almost there, Mr. Vinci. Can you raise your right hand for me, please? Swear to tell the truth, the whole truth, and nothing but the truth to help you.
Yes.
You know what, Mr. Lewis, you can just stay right there.
All right, he's going to testify, but not for much longer. There's only like 6 minutes left. And then we'll wrap it up. It'll be done with this guy. I think we pretty much have a good idea how things are going to go for him. Even though the judge doesn't rule today.
You testify from where you sit.
Okay.
Okay, so go ahead, sir.
Your Honor, on September the 3rd through September the 8th, I was incarcerated in the St. Joseph County Jail on suicide watch. I was experiencing mental health issues, Your Honor, and I did not recall ever being required to come to court. I don't recall much about the situation except for I was in a delusional state of mind, Your Honor, for several days. I was in a delusional state of mind for several days. I did mail Mr. Masters a letter requesting the appointment requesting his assistance in obtaining the body cam video of Officer Andrew Sarks. Mr. Masters stated that the prosecutor didn't have it. The body cam video was later discovered while I was on federal revocation by Attorney David Vanderkoy. I never spoke with Appellate Counsel Chris Kovalitsky about. I never gave him permission to file an appeal on my behalf. I never gave him. He never communicated with me. That will be all testified to, Your Honor.
All right, any prosecutor?
Oh, yes, Judge. I assume anything that's been alleged in the petition is fair game.
Yep.
It is true that you ended up representing yourself in trial, correct?
Yes.
And at the time you were clear-minded?
At trial?
Yes.
Like, what do you mean clear-minded?
You understood what was going on?
During trial?
Yes.
Yes, I did.
And you did observe your attorney cross-examine the victim in this case?
My attorney?
Yeah, you did. Did he not cross
Joke's on all of us, Mel. He doesn't play. He can't win because he never plays.
examine before he was removed, the victim in this case?
Yes.
Okay. And you were also present, remember that you cross-examined the victim in this case, correct?
Yes.
And you chose not to testify.
Yes.
And are there things that the victim said during the trial that, at the time of the trial, when you're sitting there, that you're thinking, this isn't right, this is wrong, I need to point out these things to you?
Oh, that sucks. He cross-examined the victim when he went pro se. Gross.
Recall any of those possibilities?
Excuse me, repeat that question again.
You recall sitting there during the trial and the victim is testifying, and in your mind you're thinking, this is a lie, this isn't right, this is not what happened. Did that cross your mind at all?
Yes, it did.
But you did not testify.
I do believe the Constitution protects
Did you
me
or did you not
from-
testify?
Did you testify?
No, I didn't.
And you,
Am I required to testify?
and the choice is for you to testify or not, correct?
Yes.
And when you chose not to, that also meant that you decided that the jury was not going to hear any version of your events or the fact that the victim may not be saying things that you consider accurate.
I decided that I didn't want the jury to hear my side of the
So you
story.
decided what happened is ended up the jury did not get to hear.
Excuse me, I'm losing you here, Deputy Prosecutor.
No, just, it's real clear. You're in this trial. You decide not to testify, but you're saying there's all these things wrong with what the victim said. You're the only person that could have clarified that, correct?
Well, Attorney Masters had the opportunity to clarify it from the beginning. I'm not understanding where you
Once you took control of that case, you're representing yourself. You are responsible for everything you did during that trial. You got to, and not only did you get to recall the victim, you got to recall the police officer and put on whatever evidence you wanted to.
After,
Is that true?
no,
Okay. Nothing else.
All right.
I don't know what you're saying.
Okay. So, I take it you both want a transcript of the hearing?
Yes.
Liz, how long would that take to be realistic?
Well, I'm really caught up now, so I can get it in a month.
Okay. So 30 days, month, give or take a few days. And so I usually give people 90 days and the point that they get everything they need. Is that going to be sufficient enough time for you?
That's more than enough time for me.
Okay. So, well,
If we could shorten it down, that'd be great.
well, I have to consider the state too, who's not just handling your case, but other cases as well. And he's probably got cases ahead of you that he needs to take care of. So I usually give the state 90 days from the point you respond and file a response. I give them 90 days to respond after you file yours.
Okay.
Okay?
So you're giving me how long
So I
time?
give you up to 90 days if you want.
Okay.
All right? Now you can't do anything for the next 30 because you won't have the transcript, or you do it at your own peril.
Okay.
Okay, but we will supply you with the transcript to both parties, and then you'll have up to 90 days to respond or to do your conclusions of findings of fact and conclusions of law.
Yes.
And then upon your filing of that, Mr. Kopinski will have 90 days in which to respond.
Okay, yeah.
Okay?
Yes.
All right. We do have an address for Mr. Lewis, don't we?
Post office box, yes, you do.
Yeah, I think we do. Okay, all right. Anything else before we conclude?
That's it, Your Honor.
All right, thank you, sir. Your transcript will be ready in about 30 days.
Thank you.
All right, so thank
You
you.
have his email and everything to get a transcript.
Yeah, I believe we do. Yep.
Okay, all right.
So you'll email it to him, right?
I will email it.
Yeah.
That'd be good, thanks.
Yeah, Mr. Lewis.
All right.
He's not incarcerated. There's nobody getting him.
Nothing.
I wonder if he already served his sentence.
All that night. Probably welcome.
Anyway, I should get the next clip ready, huh? I was watching to see if a bailiff would come and get him.
The defendant's here for a hearing.
D3, Ronald Scurry. What kind of a hearing we having here, Mr. Scurry?
I don't know. I asked for a trial by jury, and I was denied that.
Okay. Let's look here.
Your Honor, this is a state by Deputy Prosecutor Coleman, if I may, if
Yep.
you would like. So the defendant has filed a couple different motions, which the court has denied all of them. So at this point, based off of my review of the CCS, there's nothing else in front of the court per se, on behalf of the defendant for the court to consider at this juncture.
Yeah, this causes, this is post-judgment. This has already been resolved. This is a decided cause. There's nothing pending before the court at this point. Certainly cannot request a jury trial on something that is a closed matter, sir. So this case is closed.
With all due respect, Your Honor, I asked for a continuance because I had the COVID and it was a bad case. I had slight pneumonia. And so I sent the request in once I was getting better and it was granted. And I had a continuance and I still asked for a trial by jury and I still haven't received anything.
You had failed to appear back on January 7th of 2026. Default judgment was granted against you at that time.
But Your Honor, I sent in a continuance.
Only 2 months later, sir, did you file this correspondence to the court. You had entered denial to the citation on October the 6th of 2025.
But Your Honor, I was given a continuance.
Okay. Well, sir, your case is closed.
How can it be closed if I got a continuance? I received a continuance, and so that's when I filed some stuff because I still didn't receive my trial by jury.
Sir,
so
I would like viewing the entire record of this court. This was filed on August 14th of 2025. The citation was filed, the denial was filed. There was a hearing set. It was conducted on January the 7th. There was a default judgment filed thereafter. That was granted on the 13th of January. After.
So then
Mel, love, listen. If the goat is hungry, the goat's gonna eat. Some goats just don't eat a lot, or they're gonna hit a growth spurt and eat a lot. You just keep offering the food, and if the goat is hungry, the goat will eat the food. You're doing a great job.
Only after, sir, the trial date had come and gone, did you then file a handwritten notice to the court saying that you had missed your appointment and you requested a new date. That was
excuse me, Your Honor, I sent in two. So I sent in two continuances because I had the COVID and I had a bad case. So the first one was granted, then the second one was granted, and then it says your hearing will be held.
Not on this case, sir. It may have been on some other case, but not on this case, sir.
Is this 49D33-2508-IF-028180?
Yep.
That is the one I got to continue. I'm seeing it right now in my hand, Your Honor.
There's nothing in the court's record to establish that, sir.
Well, it came from your office, Your Honor.
Right. Well, your demand for a jury trial has been denied, and there are no further hearings pending before this court. No further motions pending before this court at this time.
All right. So
today's hearing, sir.
So only let the record show that I have been denied my rights.
Thank you, sir. Have a good day. That concludes this hearing. What else we got?
I've been denied my constitutional rights. How long is this clip? Hold on. We've been at it for an hour and 30 minutes. I have to see how long this clip is because I want to play it, but not if it's too. Oof. Oof. It's gonna be 30 minutes. We're gonna do it. It's a good clip. Wait, 30. Yep, we're good. We got enough time. So there's two clips in here. I left. The judge is dealing with two defendants at the same time, different crimes, completely, everything's completely different. What you don't hear, I cut out the first half of the first guy because he got busted for having meth. Not a big deal. We don't need to hear his rights and everything like that. It's the second girl that really got me. We're gonna watch this. It's really good. And then he's gonna talk to her for a bit, and we're gonna hear some good stuff. Then he's gonna break from her, and he's gonna go back to this meth guy for a little bit, and we're gonna listen, and we're gonna get involved, and then we're gonna forget all about the girl, and then he's gonna go back to the girl. I gotta go get my French bread pizza out of the oven while this starts, okay? If you send me a clip, I will, Bren, but I would never out you in a million. No one could pay me enough to play a clip of you, because I don't know if you want anybody to know who you really are.
Your matter, Ryan, while we then focus back on Brittany. You have one case. You have the charge of assisting a criminal, and that's what your agreement says you're going to plead guilty to. And so you're aware of exactly what I'm reading from now. It is a document called Criminal Information. It was filed on March 3 of 2025 in the Stark Circuit Court. The last three numbers of the cause number are 011. This is State of Indiana versus Brittany Kanchat, Kanschat. And under count one, it says assisting a criminal, a level 5 felony. That between December 2, 2024 and December 6, 2024 in the county of Stark, State of Indiana, Brittany Kanchat did assist by driving Timothy Minix, a person who has committed a crime, to wit murder, a felony, with the intent to hinder the apprehension or punishment of Timothy Minix, the Brittany Kanchat, not standing in the relationship of parent, child, or spouse to Timothy Minix. How do you plead?
Guilty.
Prima facie evidence from the state.
Thank you, Your Honor. The state would offer criminal information in the affidavit of probable cause to establish a factual.
Objection, Your Honor. Okay, then we'll show those documents submitted for the purposes of prima facie case. And now Mr. Ballard's going to ask you some questions, ma'am, so the record's clear that you did in fact commit the crime. Go ahead, Mr. Ballard.
Brittany, between the dates we're talking about, December 2nd, 2024 and December 6th, 2024, were you involved in a relationship with Timothy Minix?
Yes, sir.
Okay, and during that period of time, he murdered his father, is that correct?
Yes, sir.
And at some point during that period of time, he admitted to you what he'd done. You knew he admitted that he murdered his father, is that correct?
Yes, sir.
And after you found that out, you helped him, you took him to your mother's residence, I believe. In what county is that in? Fulton County. And you didn't make any effort to call the police and notify them of what you knew or anything like that. You took him to your mother's residence and helped him hide out there for a while. Is that correct?
Yes.
Nothing further, Your Honor.
State?
Yes, Your Honor.
Mr. Ballard asked you, you found out that Timothy Minix murdered his father because he told you. Was that the question?
Yes, sir.
And that was the question, right? And you said yes? Well, when did he tell you?
I don't remember.
Okay. Because the charge says the crime happened between December 2, 2024 and December 6, 2024.
I think it was December 6th.
Okay. It was within that range, correct? Okay. And do you have a vehicle? Were you in the vehicle? Were you driving it? Okay. And was Timothy Minix the passenger?
Yes, sir.
And you drove then to your mother's in Fulton County to hide out, Mr. Ballard said.
Yes, sir.
No, he really
Court
is
finds
famous.
defense over the age of
guys.
18.
He just
She
is.
understands the nature of the charge against her, to which she has pled.
He is famous. He has stories about him on online. He is because of his boss, but still because of him.
Guilty. She understands the possible sentence. The plea was freely and voluntarily made. It's accurate. There is a factual basis for the defendant's plea of guilty. Court takes that under advisement until sentencing. So short recess in your matter there, Brittany. While we go back to Ryan for sentencing, and there was a pre-sentence investigation report that was filed. Does the state have anything to bring to the court's attention that needs corrected there? Mr. Ballard?
No, Your Honor, my client, I've gone through it, we don't have any corrections.
Is that right, sir?
Yes, sir.
A long criminal record. How many times you been to prison? When was the last time? When did you get out?
2022.
Mm-hmm.
Got convicted in 2015.
So is there some reason to think that this isn't just another one of your dates to remember? Because there's going to be more in the future?
Oh, Your Honor, my whole life I've in and out. Like this time when I got out, I was in such a better mindset that I actually buckled down, did some programs to better myself. I got out and it was just like, I was under this mindset that, recovery, I could do it all myself. I didn't need anybody. It was all just a mindset. I did good for over 3 years. And then I just had a lot of series of bad events, a lot of deaths, broke up me and my fiance split up, lost my house. It was just like one thing after another in like a 3-week span. And I just felt I had nobody to talk to and made a dumb choice to go around people again that I've been shunning out of my life for over 3 years because they've been through the same thing.
You guys are crazy. Wanting a girlfriend, wanting 2 girlfriends. If I could dump my non-existent boyfriend right now, I would. Get out of here. I'm done with you.
I know I got to get back to doing what I did the first time I got out and shunning everybody away from my life, continuing with programs, humble myself enough to swallow my pride and ask for help and know I can't do it by myself and do it through programs and have a sponsor. That way, if something bad happens, I got somebody to talk to and not feel like it's just me alone by myself dealing with it.
All right, hold on. I'll give you another chance to talk in a second. State's argument.
Thank you, Your Honor.
What a good question, V. What a good question. Yeah, we do know why he murdered his father. We do know. Because she asked him to. That's all I know, though. She asked him to.
when you look at the PSI, I want to point out to the court's attention, and I'm sure Your Honor you read about this, but he's still on, or he still has a pending probation violation. And it looks like he's potentially facing some significant time in the Department of Correction. The revocation of his probation that has been, I don't know that it's necessarily been pending. It looks like it's been resolved, but they have been violations for use, which obviously is a violation of probation, but the probation department, where they're kept him on probation despite those positive tests. But he is still facing potentially 12 years in the department. So I don't know what's going to happen in that case, but there is still some significant time hanging over that. He does have, according to petition, about 250 days left on probation. I might not be exact about that, but he could go back to prison on this. And so the idea of this plea agreement is taking into consideration that there could be some prison in front of him still, and that this would be somewhat of a step down program for him if he were released from the Department of Correction. He does have an extensive criminal history, and that was taken into account with the amount of time that is associated with this plea agreement. And while the level 2 case isn't necessarily the subject of this plea agreement, I do want to point out that he did cooperate with the police, and that is, I think, an important thing for the court to keep in consideration as you take this plea agreement, as you consider this plea agreement.
Okay. Yeah, totally unaware of what you just said until now, but now because that's not in PSI, I don't think. But that's a factor. Mr. Ballard, your argument?
Your Honor, again, I know it's probably a lenient plea in the court's opinion for this defendant, Your Honor, but Mr. Smith is a relatively young man, and he does have quite a criminal history, but he did take some programming while he was in jail this time, and I think he completed, did you complete MRT?
Still in it.
He's still in it, I think. And I talked to him, and he seemed sincere about wanting to try and get off of drugs and lead a normal life. And I just feel like court could accept this plea and give him a chance to show the court that he's willing to live a life without committing further crimes. And I would ask court to accept the plea agreement.
Again, Ryan, you have the opportunity to say anything you want before I decide whether to accept or reject the plea agreement. You said quite a bit. You don't have to add to it. I just kind of consider that to be maybe your chance to say what you wanted to. And when I got around to here, maybe that's what you would say. What's the plan for your life? Do you have a plan?
Plan is to get to Marshall County and get that chapter over, and then I've been in contact with HealthLink, and then it's to try to get into Hope Restored and go into a 6-month program prior to ever going home.
Right.
If I was accepting community corrections, they said I'd be able to do the community corrections 6 months of it at the rehab facility while I was there, and then try to just work and get back to doing what I was doing before I started, before I went all wrong again. I just know I need to be in programs. I can't.
Right.
I got to stop thinking I can do it by myself.
It says right here that you're high risk. You're in the high risk category to reoffend. So the point of that is, if you don't change something.
Jude, no pain this morning? You don't have any pain this morning? That's awesome. That's amazing. Thank you, Jude.
That goes into the calculations, you're going to stay high risk, and it doesn't mean you're going to commit any more crimes. It just means most people, high risk, do commit more crimes. And if you're high risk and you get tired of having your freedom taken away, then change some of the factors. Now, I don't know that you're going to get more education than you have, but that's a factor. And then employment's a factor, so you might be able to change that. Certainly, sobriety or substance abuse is a factor. Family support's a factor. So, but as well as if you don't change the place where you live with all the people that you did drugs with, that's a factor. You understand that?
Yeah.
And right now you're high risk. So if I accept this, it just kind of feels like I'm just another one that said fine and sent you on your way, and nothing ever changed. And this is serious. You got yourself up now to not level 6 felonies. Now you have F4 and F2, and you cooperated, so that is a good thing for you. And law enforcement, but there's no reason to think that you're not going to be right back here again. I mean, you're going to have to pass random drug screens with community corrections, or they'll put handcuffs you and put you back in jail. You understand this?
Yes. That's why my intention is to get into programs upon getting out, and to stay in the programs. And
right. So the court accepts the plea agreement for you, Ryan, enters a conviction now for count 1. Possession of methamphetamine is level 4 felony, and the sentence on count 1 is 10 years in the Indiana Department of Corrections. 4 of the 10 years are suspended, and those 4 years are now ordered to be served on probation. Under all the usual terms of probation, Mr. Ballard, does he waive those terms read in court?
Yes, Your Honor.
So probation will go over all their terms with you, and they'll try to make sure that you're on board and your treatment's going well and all those kinds of things. But a lot of people violate probation, as you're finding out over in Marshall County while you were on probation. And then there's consequences. So you're going to do this, a 6-year sentence on being supervised by community corrections. You're going to have to change almost everything that you've ever done, right?
yes, sir.
They're serious about making sure you understand all their rules. And I don't need to even touch on them, but they will make it crystal clear, from charging the battery to making phone calls when you're supposed to, all this kind of stuff. And if you're gonna be compliant with all those rules, well then good for you. You'll be successful, but you also need to, as soon as possible, then get serious about your placement for substance abuse treatment.
My face Viagra almost wore off, Miguel. Almost. I went to work today. It looks like someone painted straight down my face something red. And because it was all swollen, all the skin is red, and it was like stretched out so far. And now my skin is like leather. It's like cracking dry because it was a rash. It was an allergic reaction. So there was this rash. It's still there. So I get to work today, and I'm like, I don't know if I should serve or not. It's not that bad. The lights are very low in the theater, so it's hard to see me clearly. So I worked today, and I tried to just look at everybody out of my right eye to hide my left side of my face as much as I could. It seemed to go fine, but then one of my sweetest little coworkers, Dickie, he's new, he's up front, he's so nice, he's such a good guy. It looks like I got bad sunburn, okay? That's what it looks like. It's all red. It looks like I have bad sunburn, and my lips are all cracked, and my face is cracked. He comes up to me and he goes, "Oh my gosh, you look so good. Did you get sun?" And I was like, I was so mad. He was sincere. He was being so nice. And I got so mad, but I not at him. I don't know. How dare you? My face is all puffed up. It's all cracked. It's all red. And he's trying to be nice to me. And I got mad at him, but I didn't get mad at him. I love him with my whole heart. But like, get away from me. Stop talking to me. Leave me alone.
You know, either residential treatment, someplace where you could spend extended periods of time. From what I see in your criminal record, this is not a 30-day program or 60-day program that you need.
No, the program that I'm doing that HealthLink is trying to get me into is a 6-month, minimum of 6 months.
Right. That's the type of length that we're talking about, minimum for you. The court may modify the sentence anytime you get 349 actual days of credit. According to this, you have to pay a drug interdiction fee of $250 in the court costs. You have to participate in all programming is directed by Stark County Court Services. The court may modify the sentence at any time, give the sheriff your DNA. And the sentence that you're ever going to receive over there in Marshall County under this cause number 50D01-1508F2007, whenever that sentence is imposed, that'll be a separate and sentence altogether. So they're consecutive, this one and that one after the other. You understand?
Yes.
Do you have anything else to talk about with Ryan Smith?
Yeah.
Do you, Mr.?
I just missed it. But did he just get 10 years for having meth? Right? He just got 10 years for having meth. Now he has to go back to that other case where he's looking at a large amount of time. And this is consecutive. So now we go back to her.
No.
You have any question about anything, sir?
I mean, if he got 10 years for having meth, what is assisting in murder going to do?
Good question. I meant to ask Ballard the other day when I spoke with him. When I go to Marshall County, my family was talking about bonding me out, hiring a lawyer to fight the case. So I guess my question is, I would start the community corrections, correct? I know they have
Marshall County. You can't start anything if Marshall County comes picks you up from our jail and takes you to Marshall County.
What a good question, Tona. What a good question. Why did he kill his father? I'll tell ya. Because his girlfriend asked him to. Because this lady right here asked him to. No. Well, V, they're not that bad. Fred, Donald, Bobby, they're not that bad. If they were that toxic, I would try to date all of them.
Yeah.
I'm saying if my family bonds me out of there, like they're talking about doing.
If you're not being held in a facility, then you could do whatever. And if they disagree with what I'm saying, they'll tell you. Okay?
So it would be up to them, basically.
Yes.
Okay.
You would want to clarify it before you have people put up money for bonds.
Yeah, I was hoping to start it immediately, is what I was hoping.
Yeah, I'm just saying you wanted to get that figured out. Any other questions, sir?
No, sir.
All right. Look. And then sentencing now for Britt and Canchat.
Oh, he would if I told him to.
Well, let me get this clear. If I accept this agreement, and it's 5 years DOC to suspend, it's at least 3 DOC and 343 days of actual credit. What does the state think is going to happen after the court imposes that sentence with Britain? I mean, physically, is he going to head off Department of Corrections? Is that your anticipation that would happen right quick, or?
For a short period, she would go to the Department of Corrections. That would be what I would assume would happen. I don't know though if they would take her for a short period of time because there's so much credit time. So I don't have a good answer to that, Your Honor. Sorry.
It's all right. How about you, Mr. Ballard?
Yeah, and I'm not sure either. It's my understanding though, if you have, anything a year or more, the department will take you now.
Congratulations,
So that's why
Don.
I'm asking you to tell me how much more.
Well, at this time, she would have, right at maybe a year, maybe a little less. I don't know, you know, she.
To do.
Yes. Yes,
Yeah.
yeah.
Is that your thinking that if I accept this agreement and sentence you under these terms, you would have about a year to do, give or take?
I think me and Mr. Phillips come up with that I have just about 15 months that I'd have to serve
15 actual
in
months
DOC, yes.
in the DOC if you served all of it?
Yes, sir.
Okay. And well, reason I'm asking right away is because whether there's been a full PSI filed or not, I wouldn't know, but there was an amended EVD and PSI filed March.
Holy cow! You were raised to disdain? You made it the whole way up to disdain? Man, good job, Brad. I'm proud of you.
10.
I did say something to Mr. Phillips about the PSI, Your Honor, and he indicated that he had that or that he's going to file that.
Just doing a cover sheet,
Yeah.
it's in file after the fact.
Yeah, he told me he was going to get it filed, so he's aware he has to have a full PSI.
Okay, so he's aware of it and what?
Well, he told me he would have it. He'd get it prepared, have it ready. I don't know. And he didn't give me a date when he was going to have it. He did say he knew he had to do it. He was going to have it. I don't know.
Okay. Well, Brittany, the reason for this conversation is that can't sentence you to the Department of Corrections, and the sheriff then transports you without what's called the full pre-sentence investigation. Ryan had a full one. It's 30-some pages of detailed information about Ryan, and that is what goes with the person when they go to prison. You don't have that because there's a time when you came for plea and sentencing, apparently, and all that we needed from the attorney's point of view was just the short one, which is fine. That's by far the majority of cases. We just need the short one. But here you are, and the sentence is going to be DOC. You have to have a full PSI to go to the DOC.
I think all he did was update it because I had my one from DOC.
Yeah, I understand. But what do you mean you had your one from the DOC?
Because, sir, when I was arrested, I was still on parole until April 18th.
We don't have it.
He probably did an updated one based on the one that she had.
No,
I don't see anything.
that's what I want to know. Is there something in existence?
I'll go double check the.
That's why I think he was just doing it.
Yeah.
At that time.
Yeah.
Right, but
Because I remember filling one out because I've had one plea and sentencing hearing already, and it was rejected. So this is my second one, and I filled out a bunch of papers.
there has been a PSI.
Yes.
It's the distinction between about a 3-page one and a 33-page one. You can't go to prison without the 33-page one. I've got the 3-page one.
Right.
It's been updated. But
I think what Mr. Phillips was going to do, Your Honor, she's been to prison before, and I
go
think,
to whenever the last one was.
yeah, I think he was
And
going
update that.
I think that's what he planned.
And it wasn't necessarily going to be done before this
Right,
hearing.
yeah. But he indicated it will, it would be done shortly.
Okay, and by the way, state have a victim's representative that you can talk about here?
Yes, I do. Emily Baker, staying here. She is Lady Menese's daughter. The defendant, Tim Menese's sister. She's here for the hearing today, but she really doesn't have much of a comment in terms of plea agreement or anything like that. She's just here for closure. And I don't believe she has I don't believe she has a victim statement she wants to make unless she's changed her mind.
Right. Very good. So,
Surveillance.
do you want me to make a decision based upon the information that I have available in the evidence-based decision-making pre-sentence investigation report?
Okay.
I'm only guessing that if I postpone this and we came back, did it again after the full PSI is done, that would perhaps is going to be updated, it would not favor you. It would probably have.
Jeez, Bren. We all jumped on that one really, really quick. There wasn't even a pause.
More criminal record and other aggravating factors. You don't have to agree with what I just said, but what you're going to have to agree to is that I go ahead and make this decision today without, I don't know, your educational level and a variety of things that I would get that I'm not going to get before sentencing, but it will be done, as we said with Mr. Phillips, when you go down to DOC. Sometimes we get hung up on some of these details, but as lawyers, you, ma'am, you want me to go ahead? Okay. State's argument.
Thank you, Your Honor. David asked the court to accept this plea agreement. Ms. Kanchat, she does have some criminal history. It is far more minimal. She has a felony possession of methamphetamine from 2013, a level 4 dealing in methamphetamine from 2023, and a welfare fraud. I'm sorry, I misspoke. A 2020 dealing in methamphetamine and then 2023 welfare fraud. That is the extent of the felony criminal history, and she does have some misdemeanor convictions. I'm assuming she was in the Department of Correction for the welfare fraud issue, because that would make sense. Role. This case has been a very long case. As Mr. Ballard mentioned earlier, this did go to trial. The family involved with this case has been through a great deal as we went through a trial on Timothy Minix, the co-defendant, and we went through a trial in this case with Ms. Kanchat. And I would just ask the court at this time to find that the plea is appropriate and accept the plea. From the standpoint of the victim's representative, they are in agreement with the plea. They are ready for closure, and I would just ask the court to accept the plea and sentence her to the terms.
Very good. Mr. Ballard.
I would agree with the state, Your Honor. I don't think Ms. Kinchet is a terrible person. She got involved with a gentleman that she shouldn't have gotten involved with, and as a result, that's why she's here today. And I would ask you to accept the plea, and I don't think she'll be an issue. She'll go serve her time.
And their families
never
that
get in
support
trouble
them,
again.
and their
Thank you.
families. Thank you so much.
Brittany, you have an opportunity to say anything you'd like to say before I decide what to do about the plea agreement.
Just sorry for the things that happened, and just don't know what's served.
Well, that's an interesting way to finish up statement. You just want it to be done and over with, but involve murder and the death of an individual. It's just not over.
I understand, sir, and I have a lot of remorse for the family. I really do. They have gone through a lot, and they shouldn't have had to. That family has lost out on a lot. A little girl don't get to know her grandfather. A daughter don't get to know her father. That family has lost a lot for no reason.
Okay, I appreciate that a little bit more than what I had heard.
It was senseless.
The court accepts the plea agreement, enters a judgment of conviction for count 1, assisting a criminal as a level 5 felony. You're sentenced to the Indiana Department of Corrections for a period of 5 years. 2 of those years are suspended. They'll be served on probation. And Mr. Ballard, does she waive the formal reading of all the probation terms in court?
Yes, Your Honor.
You have to participate in all programs directed by Stark County Court Services. You have to pay the court costs. The parties agree you're entitled to 343 actual days of credit to be applied to the sentence. The court may modify the sentence at any time, and the court orders you to give the sheriff for DNA. Pursuant to the terms of the plea agreement. State have anything else? Mr. Ballard, anything else?
No, Your Honor.
Ma'am, do you have any question about anything?
No, sir.
We're done.
Thank you.
So she gets a year. He got 10 years. She got 2 years? Okay, 2 years. He got 10 years for having meth. Yeah, it checks out. She didn't actually do anything, though. She just drove the murderer around to her mom's house. But she asked him to do it. I think they should have leaned into that more. I think they said that in one sentence at the beginning. All right, I know I went over. I took up your time again, guys. I just pretend it's mine to use as I want. Thank you so much for staying for so long. I appreciate it. I do. Got more good stuff tomorrow. Wait, what is today? I better make sure. Okay, it's not Sunday tomorrow. Don't worry, it's Friday. It's Friday tomorrow. Woohoo! So, behave today, and I'll see you all very, very soon. Thanks, guys. I'm waving right now, just so you know. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, and see for yourself.